I'm here to tell you about the complaint that Montagraph's lawyer filed against me. He filed this on January 27th. I've not talked about this complaint because I wanted to file my response before I did. This normally, the complaints that I get, ethics complaints that I get, are dismissed without any investigation. This one required me to at least respond to determine if they want to investigate further. So I have responded now, and so I figured I'd go ahead and talk about it. This is from his attorney, David Schneider, and it's in response to a statement I made on January 18th here on Locals behind a paywall. Behind a paywall. So one of these streams that we're on right now. Now, the statement in question, if you guys remember the timeline of what happened here, on January 13th, Montagraph's lawyer filed for a default judgment against me. And on January 13th, I filed a motion in court for an extension of time to file my answer, because even though I had made a timely request to David Schneider to extend my length of time to answer due to the Christmas and New Year holidays, making it hard to retain counsel and actually get a proper answer drafted up to answer the lawsuit in a professional manner, I requested an extension till January 31st, a reasonable request, which should be granted a million times out of a million, because there's no urgency, there's no prejudice to the other party or anything like that. So despite me making that request, he refused to simply answer my phone call, my email, my follow-up phone call, the follow-up phone call to that, my follow-up email, and my follow-up in-person appearance at his office. He refused to answer any of those things. He admitted to refusing to answer those things in his motion, in his affidavit on his motion for dismissal. That was on January 13th. Now, I made a statement on January 18th that his behavior was him being an absolute cunt. Okay? So that's what I said. I said, I don't know why he's being, or something like, he's being an absolute cunt about this. And the problem with this, of course, is that was true. That's a true statement. He was being a cunt. I was very surprised by the way that he was acting in the way that he was, because my experience with him is not that of a cunt. My experience with him prior to this lawsuit was that of a professional attorney who engaged openly in communications with opposing counsel and had no trouble actually doing anything. So he filed an ethics complaint about me for saying that he was being an absolute cunt. He based his ethics complaint on 3 separate rules of professional conduct. I will go through them with you by memory because I can't pull them up. The first one is Rule 4.4a. But Rule 4.4a of professional conduct is that in the course of representing a client, a lawyer shall not undertake any action which is intended to harass, embarrass, burden, or otherwise infringe upon the rights of third persons. Now, I know what you're thinking. You weren't representing a client. That's true. It's a big problem on that one. I wasn't representing a client. Now, his argument on this is that I was self-represented on January 18th when I made the statement that I was representing myself, therefore I am the client. And this isn't really how this works. Pro se representation isn't representation of a client, it is self-representation. But I guess you could make the argument in some way that as a lawyer, even though I'm pro se, I'm bound to the rules of client representation. But we have a little problem here. On January 18th, I was not represented by counsel, or I was not self-represented. I was represented by counsel. I had retained Mark Randazza prior to January 18th. Now, I had filed my motion pro se on January 13th, as my attorney had not made an appearance in the court, before the court at the time, and he would have to be waived in pro hac vice because he is not licensed to practice in Minnesota. He has to get special permission from the court. He would receive that special permission on January 20th. He would file his motion for admission on January 19th. But nonetheless, on January 18th, when I made the statement, I was already represented. Now, it would have been easy for Mr. Schneider to understand that I was represented and figure this all out if he had ever responded to a single goddamn email or phone call that I sent. The guy chose not to engage in communications with the other party in a lawsuit that he had filed. And this is even after I made appearances in the lawsuit. Again, filing on January 13th, I had to appear before the court to make that filing. So he can't use the excuse that, well, I just never answered in any way, which would have been untrue in and of itself. But he just decided to not engage in any communication with me at all. If he had communicated with me, I would have simply communicated that I was represented by counsel, given him the contact information for my counsel, and then he could communicate with Mark rather than with me, which apparently he doesn't want to do, so that's fine. He seems to be communicating with Mark just fine. So, importantly, he would file this. He would file this complaint on January 23rd of this year. So by the time he filed the complaint, he knows I was represented because Mark was actually represented. He was admitted into the court again on January 20th. But nonetheless, 4.4a applies to someone acting in the course of representing a client. I was not representing a client. And furthermore, a big problem for him is that my expression of distaste with his behavior does not in any way impact or burden rights. In fact, comment number 1, which talks about 4.4a specifically, really clarifies that the rule is basically written so that someone is not interfering with a privilege like an attorney-client relationship or something like that. Some cognizable right. You have to interfere with a right of the party to violate Rule 4.4a. And you have no right to not be called a cunt. You have no right to not be insulted. You have no right for any of this at all. So that's his first problem right there. Now, he goes on to explain that that in 27 years of lawyering, he has never been called a cunt, that he's very open to criticism of his work, and he is fine with free speech. Totally. He's totally cool with free speech, guys, despite the fact that he's filed frivolous litigation in regards specifically to free speech, despite the fact that he has now filed a complaint directly trying to silence my free speech. Despite all of that, he's totally cool with it. He's good with free speech, y'all. However, being called a cunt is a vulgar term that in 27 years he has never been called. Well, welcome to the rice paddy, motherfucker. It's you're dealing with a brazen asshole who insults people for a living. But that being said, he stated that I did this on my broadcast, and that I did it for the sole purpose of embarrassing or harassing him, which is not true. And this is another part of the problem for him. See, I didn't do this on my main broadcast. I didn't do this on the main show, right? The main show is broadcast to between 10 and 15,000 people on average every night. And the main show will be viewed by between 150 to 250,000 people on average every night, like once the people watch the replays and stuff like that. That's my main show. I did this on a paywalled locals subscriber-only live stream. And on that subscriber-only live stream, only 3,243 people as of this, or as of the writing of my response, had watched that video. So we're talking about a small fraction of the audio, of the general audience was exposed to this. It's not like I was out blasting this lawyer on some public thing. I was venting to a group of my closest supporters what had happened. Was it clipped? Yes, of course it was. It was probably clipped by Montagraph, frankly. Montagraph is probably watching this show. Hey, Montagraph, stop raping melons, you weirdo. Stop it. Fucking weirdo. What are you doing? Those melons didn't do anything to you. Gross. Gross. Also, stop being fucking weird. Just go be a normal guy and do your conspiracy shit. People actually like that content. Why don't you go do it? I don't know why. You're obviously retarded. Well, we're gonna show them. We're gonna show them. Oh yes, they don't understand how powerful we are. Okay, go for it. Yeah, whatever. You go do that content. You take on the CIA or the FBI or whatever you do, and you'd probably be fine. People eat that shit up. But instead, you go on these weird crusades against people and then try and silence them when they make fun of you. You deserve to be made fun of. You're retarded. You're an idiot. Okay, anyway. So he's probably in here watching. So, but that being said, I didn't go out to the public forum and blast Montagraph's lawyer. I was talking to my closest supporters here on Locals and expressing frustration with how he acted. So you've got this issue where he said I only did that the only purpose was to harass or burden him, and I didn't harass or burden him. In fact, he would have to go to great lengths to come to the alleged harassment, which puts him in a precarious position under Minnesota law. See, you can't harass someone by talking about them in a place where they're not. Right? Now imagine, for example, we have a private meeting somewhere. I rent out a little like a hall or whatever, and I'm going to give a private speech that you have to pay $5 to come to, right? So people can come and pay $5. And at this speech, I go and I don't invite anybody. Like it's open to whoever wants to come in. They can pay $5 and they can come watch. But I don't send the invite to Mr. Schneider or to Montagraph or anybody else. I don't like say, hey, you need to come see this. This is. I don't send it to their mom. I don't try and notify them to come do anything. It's just generally open. All right. And then at that thing, I say, well, so and so is being an absolute cunt. And that person pays, again, without a specific invitation, they pay to come in and hear that. And they're like, hey, I'm being harassed. How? How are you being harassed? You're not. Under law, you are coming to the conversation. Now, if I were to record that segment and clip it out and email it to him and mail it to his mom or his like kids or whatever and try and shit on him, that would be harassing behavior. Absolutely. Something I didn't do in any way, didn't ask anybody to do, don't care, don't know if he would ever see that or this. I mean, he might see it, but he'll only see this if he either pays or has someone else pay to come to the conversation. He's not invited. I didn't send him the link. And I frankly don't care if he sees it or not. But right now, he's got a problem. One of two things. He's either completely stupid and has no idea what the First Amendment is, what it means, what harassment law is in Minnesota, or he does know, and he's trying to use the Lawyer's Professional Responsibility Office as a hammer against me to silence my free speech. I think it's probably the second, because I don't think Mr. Schneider's an idiot in regards to the law. I think maybe he may not know what he's doing in the defamation case. In general, I don't think that. But I think he's competent as a lawyer and certainly capable of looking up Minnesota law on harassment. So he should know what he's doing here. And I think he does, which I think makes him a little dishonest. If I'm being frank on it, and I of course will be frank on this, I think he's being dishonest, and I think it's actually disgraceful to the profession to do so. But you know, what am I? I'm not his mom. But that's the first rule. He actually cites 3 total rules. That's the first rule. But again, this comes to the problem of I'm not representing anybody on January 18th, not even myself at that time. And so that rule should fail automatically. And second, I didn't do anything to embarrass, burden, harass, or delay him or to infringe in any way upon his rights. You do not have a right to not be called a cunt. Doesn't exist. There's no right. I can't come into your house and do it. I can't come into your workplace and shout at you. I can't call you repeatedly. I can't like fax you over and over. I can't spam your email with you're a cunt, you're a cunt, you're a cunt. I can't do any of that stuff, which of course I didn't do. But me simply expressing an opinion about you in a semi-private way to people, it would be akin to me standing around with some coworkers somewhere and just going, you know what, that guy's a cunt. And then someone saying, hey, do you know what? He called you a cunt. He's like, he's harassing me. How? How without someone going and telling you, you would have never known it happened. It's not harassment. How does that harass or annoy you in any way? So the second rule, second alleged violation that he cites is the bane of the ABA model rules. It's rule 8.4G. Brace yourselves for this one, ladies and gentlemen. 8.4G is a rule that prohibits a lawyer from harassment based on age, race, gender, sex, sexual orientation, gender identity, national origin, ethnicity, whatever, religion, all of those things. He claims that by me calling him, first of all, I didn't call him a cunt. I said he was being an absolute cunt, which is not who someone is, but how they're behaving. I think there is a distinction. If I say you are a fucker, or if I say you're acting like a fucker, I think those are two different things. But maybe not. Maybe there's no distinction there. I think there is. I think saying someone is a piece of shit is different than they're acting like a piece of shit. But okay, so but to be clear, I said he was being an absolute cunt. But I want to know how in any way me calling a man a cunt one way or another is discrimination based off of gender or sexual orientation. Oh, or marital status. Because he cited gender and marital status. I'm not joking. I'm not kidding. Apparently cunts can't be married, which we know that's not true because I'm married. So I'm obviously a cunt. Like I know that. So I'm trying to figure out how that would be some sort of harassment based on gender or marital status. Now, in a way, I could actually see if you like were to repeatedly utilize cunt towards a woman, that could be sexual harassment in the particular context where like sexual harassment would apply. I guess you could maybe get there. Like, for example, in a workplace, if you're in a workplace and you're calling someone a cunt constantly, that would probably violate a woman specifically, that would probably violate a sexual harassment policy in the United States. Whether it should or not is a different question. Whether it would, I think you'd get in trouble for sexual harassment if you repeatedly called particularly women cunts. You'd be discriminating and calling them a derogatory slang that's often directed at females. That's how you would get there. Okay. But we're not in a workplace environment. We're not under some employment contract or agreement. We don't have an employee handbook between the two. I don't owe him any duty to treat him with any particular dignity or indignity in any way. So 8.4G is a problem. First of all, 8.4G is problematic in and of itself. 8.4G, well, we actually have another rule. The comment 5 on rule 8.4, which pertains to 8.4G and 8.4H, which we'll get to next. Comment 5 specifically says that 8.4G is within the scope of representation. So again, while representing a client, somehow in litigation, all of this is related to my protected First Amendment activity of broadcasting a show as somewhat of a shock jock who engages in, according to their own lawsuit, hyperbole and comedy and is often vulgar. That is not the representation of a client. In no way when I'm talking to my locals, am I representing a client? Even if I was pro se, even if I was self-representing at the time, which again, on the timeline I wasn't, but even if I was doing that, me talking to locals, me doing a live stream, me talking to YouTube or Rumble are not in the scope of representation. That is just me doing a show. That is me doing a production, a broadcast. That's the first problem. Second, none of this is harassment. And third, it's not based on gender. It's not based on marital status. That's just a frankly idiotic take. Again, I don't know how calling anybody a cunt could feasibly be impugning a marital status in any way. But I do have to give him some praise. He did make me laugh in his comment. All right. And this is the main reason I wanted to bring it up, because I wanted to get his quote just right. But I'm going to have to go off of memory on this one. This is good. He got me on this one. He got me on this one. He said, he doesn't know if me, identify as homosexual or transvestite, but because I used a slur of a sexual nature and he is a man, I must identify as gay or transvestite. Which I don't know how that follows, but it's funny. He's like, so that was good. That was good. He got me there. Total fake. So hats off, Schneider. I know you'll see this one, and look. That was good. That's how you got to do it. That's how you got to do it. But you shouldn't have done it. You shouldn't have done it in an ethics complaint. That was retarded. Doing it would have been funny. You should have just sent it to me. Been like, are you gay? Are you hitting on me for calling me a cunt? Because cunt is a sexually oriented insult, which it isn't. I mean, that was a weird thing. He used dictionary.com to define cunt, and then stated that since it was sexual in nature, that's how he did it. But I mean, at least he got there, and it was cool. It was cool. So I thought that was actually funny. I do want to point out that, interestingly enough, if something were to violate the rule against sexual orientation based discrimination, what he said is much more likely to violate the rule than what I said. Right? Now, he did it within a complaint, so it's protected speech, I guess. But the fact that he suggested that I must be gay because I used the word cunt would be discriminatory by nature. So it's kind of weird on that one. But whatever. I mean, I guess. So that's 8.4G. Again, not representing a client, so 8.4G doesn't apply according to comment number 5. Also, not harassing behavior for the reasons described above, and certainly not based on gender, sexual orientation, or marital status, or race, creed, national origin, religion, any of those things. Age. Well, I may be a bit of a boomer. I wasn't discriminating against him on that. 8.4H is even the weakest one of the 3. And that's saying something because the first 2 are really weak. But 8.4H requires you to do engage in activity that's prohibited by statute or local ordinance. So there isn't a law against calling someone a cunt. So if there isn't a law against it, if it doesn't violate an actual law, then 8.4H just simply doesn't apply. But 8.4H does apply outside of the representation of a client. So you could, in theory, if you violate a law that exists, and this is typically related to that harassment and discrimination, same stuff as 8.4G, but it would be violative of a local statute or ordinance. So since there isn't a law against calling someone a cunt, that one should just fail outright. But I sent a very long response today to the Professional Responsibility Office. And hopefully they can just go ahead and put this to bed. Obviously, this is a frivolous complaint. It's a frivolous complaint aimed at silencing my speech, the same way that his frivolous bullshit lawsuit is aimed at silencing my speech. Montagraph had also previously filed an ethics complaint and failed to silence my speech using the Lawyer's Professional Responsibility Office. Montagraph has filed several vexatious, frivolous lawsuits against people to try and silence their First Amendment speech. He tends to not win those lawsuits. In fact, one of them, Morphinos, is how I learned. I think Jake Morphinos is his name. Is how I learned about Montagraph in the first place. I was on a stream with Jim, June 29th of 2019. Mr. Medicare, I was on his live stream, and he was explaining to me the Jake Morphinos lawsuit against Montagraph. And he was asking me various questions, and I talked about it. This is how I learned about him in the first place. He filed a frivolous lawsuit against Jake Morphinos for defamation. The same thing. Monty has a little history of this problem. Now, Jim had done a previous live stream on the 26th of June, 2019. You can find these live streams; they are still archived out there, but they're not on Jim's channel. But yeah, so you can go find out about this stuff. It's where I first learned about Montagraph, and then I would be contacted by Montagraph a couple days after that. That's where the saga began. I do want to point out that to Dave Schneider, if you're still watching this, if you ever happen to see it, in mid-December of 2019, Montagraph threatened to come to my house and visit me in person without being invited. Your client has a history of stalking and threatening people, stalking digitally, and then threatening to do things to them physically in person. He threatened also to release my docs information, which he clearly was lying about having, because you still sent the lawsuit to the wrong address initially. You still had the wrong address for me. So Montagraph clearly didn't have my information that he claimed to have, which is sad because he was probably going to harass like just a decent family at a different address. But that's what your client does, Dave. You should know that. And you should also probably watch out, because your client will probably be mad if you don't win this lawsuit. And I would strongly suggest that you steel yourself against this client, because he has a history of being a fucking idiot. You'd know this if you'd done any research into this client, which you don't have any duty to do so. And you, of course, can go ahead and represent him zealously, as you expect to do. That's your job, and Monty deserves representation. Don't ever let me suggest that he doesn't, or that you shouldn't represent him. But I just want you to know what you're getting into. You probably maybe should have checked in on this guy, and when you filed the lawsuit, I would hope that you realized the pitfalls of your lawsuit, because what I've said about Montagraph is largely true. And if you don't think it's true, it was probably an obvious joke. But the melon thing happened on camera. And his little snuff film that he's very proud of, The Umbrella Man. I call it a snuff film. Did he actually kill a kid in the video? No, I don't think I ever alleged that, by the way. But I'm pretty sure that's what he's supposed to be. Anyway, the Umbrella Man, that that whole thing, that's that shit that he did. And it's not hard to find this shit. And the only reason I said all of the things that I said about Montagraph is because that's what I've read about Montagraph. These complaints have been around for a decade. The guy's a weirdo. So you've got some pitfalls there. But more importantly, you have on your hands a nut job. And I hope he paid his retainer because I don't think he has any money. So I have filed my response. I have informed the Professional Responsibility Office of the obvious frivolous nature of what's going on here with Dave Schneider's complaint, with Montagraph's lawsuit, with Montagraph's prior complaint. Um, there's there's no merit to any of it. He knows he knows there's no merit to any of it, and he's attempting to use it to suppress the First Amendment because that's what he wants to do. I don't know why Mr. Schneider has a problem with the First Amendment, but I will vigorously and unapologetically defend my right to use the First Amendment to the fullest extent that I choose. And the cool thing about the Lawyer's Professional Responsibility Office is it is an agent of the state, so the First Amendment definitely applies, and lawyers don't forfeit their First Amendment rights um, to do anything. We have the full protection of speech. Actually, in our employment, we actually probably have more speech protection than most people do because our managing entity is a government body. It's not a private board. It's not some non-government entity that self-polices or self-regulates. It's literally um, the state. So the state has to punish you for speech. And if the state tries to punish me for speech through the Professional Responsibility Board, especially protected speech that's done on a broadcast, then the state, as I said before, when they pulled the same shit last time, as I said before, the I'm willing to fight the state on this as much as I need to do. I would prefer not to because I'd prefer they just go with the obvious solution, which is to uphold the First Amendment that they are bound to, that we all took an oath to protect. But um, if they decide to come after me on it, then obviously I will just go ahead and fight with them to the fullest extent necessary. But I don't think that's going to be necessary at all, personally. These frivolous complaints happen all the time. And I think the only reason that they're even looking into it in the first place is just because I happen to have an existing lawsuit. And Mr. Schneider wrote it in a way to suggest that I was representing someone, even if it was myself. And again, he was mistaken on those facts, and that can be proven pretty easily. Um, and he would have known that if he had just engaged in the basic professional courtesy of responding to the opposing party when they reached out multiple times. But so there you guys go. There's an update on what happened with regards to my current ethics complaint. We'll see. I'm out here breaking ground on Minnesota professional ethics as a professional ethics tester. I was hired by the government, by the U.S. government specifically, to test the ethics systems in Minnesota. But yeah, I don't know. It's petty stuff. It's the type of shit. It's petty lawfare, and it's just intended to cause uh, a burden to me. Like that's why he did it. I don't think Dave Schneider is at all offended. He's an attorney. I don't think he's at all offended by me saying he was being a cunt. Um, I I met the guy. The guy seems completely down level, right? He just thinks this might be able to give him some sort of advantage or burden me in some way in the active litigation. So that's my opinion. I don't actually know. Maybe he's super offended. Maybe he's really like hurt by it and he's going to therapy or whatever. I just really doubt it personally.